This is a single sheet of paper that can take back a car you already own, not repossess it. Take it back legally as though the sale never happened, and there is a second piece of paper in the same stack that makes sure you can never stand in a courtroom and object. The two documents are almost never discussed together. Separately, each one sounds like boring administrative housekeeping. Together, they form something close to a perfect machine, and once you see how the pieces lock, you will never sign a stack of dealership paperwork the same way again. Start with the phone call because that's how most people find out. It comes 4 days after you drove home, sometimes 11 days. There is a pattern to the timing, and the pattern is not an accident, but hold that thought, because we'll come back to why the delay matters more than almost anything else in the story. The voice on the other end is friendly, apologetic even. There's a small problem with your paperwork, nothing serious. Could you come in and see the finance manager just for a few minutes? They will not tell you on the phone what the problem is. That is also deliberate. Here is what has actually happened. When you signed a retail installment sale contract, and somewhere in that stack, you also signed something with a name like spot delivery agreement or conditional delivery addendum, or simply a line inside the purchase order stating the sale is conditioned upon approval of your proposed financing. You drove off believing you had bought a car. What the paperwork says is that you have been loaned a car while the dealer tries to sell your loan to somebody else. That distinction is everything, and almost nobody who signs it understands it in the moment. The dealership is not a bank. It does not, in most cases, lend you the money. It writes a contract and then shops that contract to lenders, and the lender decides whether to buy it and at what rate. Consumer advocates have described the effect plainly. Because of the way these laws are written, every single transaction is a potential yo-yo, not the suspicious ones, not the subprime ones, every one. Now, the timing. Why 4 days? Why 11? Because you need time to fall in love with it. You need to have parked it in your driveway and taken a photograph. You need to have driven your mother to lunch in it, put insurance on it, told the people at work. Attorneys who handle these cases describe the waiting period in exactly those terms. The dealership waits deliberately until the buyer has grown attached and would be embarrassed to give the car back. Returning it stops being a financial decision. It becomes a humiliation. And while you were falling in love with it, something else was happening to the car you traded in. This is the part that turns an unfair sales tactic into a trap with teeth. In the first contract, you handed over your old vehicle. In the days that follow, the dealer sells it or sends it to auction. It is gone, physically gone, before you are ever called back in. So when you sit down across from the finance manager and he explains that the rate is now higher or the term is now longer or that you need a cosigner, and you say the obvious thing, fine, unwind it, give me my old car back. The answer is that your old car no longer exists to give. You now have no vehicle at all unless you sign the second contract. That is the machine's first half. Hold on to the feeling of it, because the natural human response to hearing this is a single word: sue. And the answer to that word is the second piece of paper, and the second piece of paper is genuinely stranger than the first. Turn the page in your own stack if you still have it. Somewhere in there, usually on the reverse side of the purchase agreement, printed in type noticeably smaller than everything around it, is a paragraph with a heading like arbitration provision or agreement to arbitrate disputes. Read it once and it sounds procedural. Read it carefully, and it says this: you agree right now, before anything has gone wrong, before you have any idea what might go wrong, to give up your right to take this dealership to court, ever, for anything, not this dispute, any dispute, fraud included. The Consumer Financial Protection Bureau describes the effect in flat language. By signing, disputes go to an arbitrator instead of a court, and that arbitrator is usually chosen by the dealer or the lender. You may also lose the ability to appeal the decision and the ability to join a class action. Consumer attorneys put it less gently. Translated out of legalese, the pre-printed, non-negotiable language means car buyers cannot use the public court system to sue a dealer for fraud, for breach of contract, or for most of the claims that would otherwise be available to them. And then there is the detail that, once you notice it, is difficult to unnotice. The clause generally binds you. It does not, in the same way, bind them. The dealer or the lender who financed the sale can turn around and sue you in court. The door swings one direction. Now put the two documents side by side and watch what happens. Document 1 gives the dealer the right to unwind your deal after you have taken the car home, at a moment when your trade-in has already been sold and you have no leverage left. Document 2 removes the forum in which you would contest it. The first creates the injury. The second closes the exit. Neither is illegal. Each, examined alone, has a respectable sounding justification. It is only when you see them as a pair that the shape becomes clear, and virtually no buyer ever sees them as a pair because they are signed 90 seconds apart in a small office while a man makes conversation about your weekend. But this raises a fair question, and I want to take it seriously rather than skate past it, because the honest version of this story is more damning than the simple one. Arbitration is not inherently a scam. It exists for real reasons. It is faster than litigation. It is cheaper than litigation. Court dockets are genuinely clogged, and a dispute over a $2,000 add-on does not need 18 months and a jury. If you had a legitimate complaint and someone offered you a fast, cheap, informal hearing, you might reasonably take it. The word doing the work here is offered. The distinction that matters, and it is the whole distinction, is between arbitration you choose after a problem arises, and arbitration you were required to accept before you knew a problem was possible. The first is a tool, the second is a waiver. And the people who understand that difference most clearly are not consumer advocates. They are car dealers. We will get to how we know that, and it is the most extraordinary part of the story. First, what actually happens when someone tries to use the system. Consumer Reports documented the case of a buyer named Perz, and the details are worth sitting with. He had a claim. He went to arbitration as his contract required. The dealership then refused to pay the arbitration fee it owed. Because the dealer would not pay, the arbitration firm that had been designated in the contract stopped hearing that dealer's cases altogether. His case went nowhere, not because it lacked merit, but because the forum he was contractually locked into had stalled. Years passed. Throughout them, he was paying off a vehicle he could not use. Eventually, a different arbitration firm heard the case and ruled against the dealership. He won. Read that outcome carefully because it is the optimistic version. He won, and it still cost him years in payments on an unusable car, and he had no ability to go anywhere else while it happened. Now consider what that means for every claim smaller than his. This is the quiet arithmetic underneath the entire arbitration debate, and it explains why the class action waiver buried inside these clauses is not a footnote. It is the main event. Say a dealership adds an unauthorized fee of $400 to every contract it writes. $400 is real money to the person paying it, and nowhere near enough to justify hiring a lawyer, filing individually, and pursuing a case alone. No attorney takes that case on contingency. You would spend more fighting it than you lost, so individually the rational choice is to absorb it and move on, which is precisely what almost everyone does. Multiply it by 8,000 customers and it is $3.2 million. The class action exists to solve exactly that asymmetry, to let a harm that is trivial to each person and enormous in aggregate be addressed at all. Strip out the class action, and you have not merely changed where the case is heard. You have made a whole category of misconduct structurally unchallengeable, not defensible. Unchallengeable. The claims do not get resolved in arbitration instead of court. They stop existing. Consumer Reports made the same point from the other end, and it is a genuinely unsettling observation. It is impossible to know how many disputes are never pursued at all because the people harmed cannot sue and cannot act as a group. There is no docket of the cases that were never filed. The harm leaves no record. California is where this got tested hardest, and the outcome tells you how firmly the ground is settled. In 2010, a class action was filed over the purchase of a used Mercedes. The purchase agreement contained a standard arbitration clause. The trial court refused to enforce it, finding the agreement unconscionable and holding that the right to bring a class action could not be waived. The Court of Appeal agreed the provision placed an unduly oppressive burden on the buyer. Two courts both siding with the consumer, then it reached the California Supreme Court, and in 2015, that court reversed both of them, 6-1, and upheld the clause. The reasoning ran through a 2011 United States Supreme Court decision holding that the Federal Arbitration Act preempts state rules prohibiting class waivers and consumer arbitration agreements. State consumer protection law, in other words, could not save the class action because a federal statute written in 1925 had been interpreted to override it. That is the wall. It is not one dealership's aggressive lawyering. It is federal law as currently interpreted, and it is why the paragraph on the back of the form has held up against sustained, well-funded, repeated attack. Which brings us to the thing I have been holding back since the beginning of this video. Because if you have been listening closely, a question should be forming. If mandatory pre-dispute arbitration is genuinely fine, efficient, fair, nothing to worry about, then it should be fine for everyone. It should be fine for the dealership too. In 2002, Congress passed a law called the Motor Vehicle Franchise Contract Arbitration Fairness Act. It is now codified at Title 15, Section 1226 of the United States Code. And here is what it does. It prohibits automobile manufacturers from putting pre-dispute arbitration clauses into their franchise contracts with dealers. Under that law, a dispute between a manufacturer and a dealership can go to arbitration only if both parties agree in writing after the controversy has already arisen. Read that again with the first half of this video in mind. Car dealers went to Congress and successfully argued that being forced into binding arbitration before a dispute exists is unjust, and won a specific carve-out from the Federal Arbitration Act, the first such exception legislated since the Supreme Court began expanding that act's reach. It passed with bipartisan support and more than 250 CO sponsors. It was signed by President George W. Bush. The National Automobile Dealers Association pushed for it. The argument they made is the part that should stop you cold. When Senator Orrin Hatch introduced the bill, the stated justification was that dealers needed protection from mandatory arbitration clauses imposed on them by manufacturers because of unequal bargaining power. Dealers, the Senate report explained, were effectively economic captives of the manufacturers. They could not meaningfully refuse the terms, so requiring them to sign away the courthouse in advance was unfair. Every word of that is true. It is also, word for word, the situation of a person sitting in a finance office at 8 o'clock on a Saturday evening, being handed a pre-printed form with no negotiable terms, who has already sold their old car, needs transportation to get to work on Monday, and is told that if they will not sign, there is no deal. Unequal bargaining power. Economic captivity. Take it or leave it. The dealers were right. They were describing something real. They simply drew the circle of protection around themselves. In 2008, Congress held hearings on a bill called the Automobile Arbitration Fairness Act, whose entire purpose was to extend to car buyers what Congress had already extended to car dealers 6 years earlier. The hearing record states the aim in exactly those terms, granting automotive consumers the protection dealers received in 2002. It did not become law. So the situation today is this: a dealership cannot be forced into pre-dispute binding arbitration by Ford. You can be forced into pre-dispute binding arbitration by the dealership. The identical practice, described by the identical argument, is prohibited in one direction and standard in the other, and the difference is not principle. It is who had a lobbying operation in Washington and who did not. That is the machine complete. Now, what actually protects you? Because the point of knowing all this is to never need any of it. The single most effective move happens before you ever walk onto the lot, and it neutralizes the entire first half of this video at once. Arrange your financing independently. A bank, a credit union, anywhere that is not the dealership. Walk in with an approval already in hand. Understand why this works so completely. The yo-yo depends on one structural fact, that the dealer is arranging your loan and can therefore claim it fell apart. If your financing is already secured elsewhere, there is no pending approval to fail, no third-party lender who mysteriously declined, no reason for anyone to call you back in. The lever does not exist. Regulators and consumer advocates converge on this advice for exactly that reason. Second, before you sign anything, find the conditional language and read the actual words. You are looking for phrases like subject to financing approval or conditional delivery, or a sentence stating that the sale is conditioned upon approval of your proposed retail installment sale contract. If it is there, the deal you think you are completing is not complete. A narrow, honest contingency has specific features. It names the lender, it states a deadline. The dealer may void within a set number of days if a named lender does not approve. It is initialed separately, so you cannot claim you missed it. A broad, vague financing contingency buried in fine print with no name lender and no time limit is a different animal entirely, and consumer attorneys treat it as the signature of a spot delivery trap. Third, and this one is nearly free, do not let your trade-in leave until the financing is genuinely final. This single decision removes the hostage. If you keep possession of your old vehicle until the loan is funded, then the worst outcome of a callback is that you return their car and drive away in yours. Inconvenient, survivable. It is the difference between a bad afternoon and a catastrophe, and it costs you nothing but a few days of patience. Fourth, look for the arbitration paragraph specifically and know that you are permitted to ask for it to be struck. The Consumer Financial Protection Bureau says so directly. The dealer may refuse, they usually will, but their refusal is itself information about what kind of business you are dealing with, delivered at the only moment when walking away is still cheap. And if the call comes anyway, do not go in that day. There is no legitimate financing problem that requires you to appear within hours, and the urgency is manufactured precisely because it works. Ask for the rejection in writing, from the lender, naming the lender. A real declined application generates a real paper trail, and a dealer who will not produce it is telling you something. Do not sign a second contract in the room. Nothing obligates you to sign anything on the spot, and the entire tactic is built on the assumption that you will feel like you must. Get your own copies of every document from the first transaction before you go anywhere near a second one. And know that the situation is not as hopeless as the arbitration clause makes it feel. Federal and state laws still apply inside arbitration. Truth in lending requires accurate financing disclosures. State consumer fraud and unfair practices statutes remain available, and some carry treble or punitive damages. Several states regulate spot delivery directly. In Illinois, if the dealership cannot find financing at the contracted rate, it must return your down payment and your trade-in. Some states require the dealer to honor the original terms or unwind the deal entirely, with renegotiation at worse terms simply not permitted. Consumers routinely assume that conditional delivery language means they have no rights at all. That assumption is wrong, and dealers benefit from it enormously. But notice what all of that requires. It requires you to know it in the moment, under pressure, in a small office, at night, while someone tells you this is just a formality. That is the real design. Not one villainous clause, but a stack of documents, each of which is individually defensible and collectively airtight, presented at the exact moment when a human being is least equipped to read carefully, tired, excited, committed, and already imagining the car in their driveway. So go back to the phone call 4 days later and see the whole shape of it now. The friendly voice, the unspecified problem, the delay that let you get attached, the trade-in already sold, the second contract waiting on the desk. And underneath all of it, on the back of a page you signed without reading, a paragraph confirming that whatever happens next, it will not be happening in front of a judge. The paper was never the record of your deal. The paper was the deal.